the 8-1 decision that just rewrote the rules on gun rights in America. What started as a bold state law turned into a Supreme Court showdown that's sending shockwaves through every courthouse and legislature in the nation. This isn't about politics or opinions. This is about the future of how your constitutional rights are defended, challenged, and reinterpreted by the highest court in the land, and what it means for every gun owner who believes the Second Amendment still matters. Before we break this down, hit that subscribe button and turn on notifications, because these legal fights are moving faster and getting more complex than ever. And if you care about protecting your rights, you need to stay ahead of what's happening in these courtrooms. The law that made federal agents powerless. Missouri didn't just pass a gun law in 2021. They created a legal weapon that threatened to make federal enforcement impossible. The Second Amendment Preservation Act went further than any state had dared before, imposing a $50,000 fine on any law enforcement officer who helped federal agents enforce gun laws Missouri deemed unconstitutional. Within 6 months, over 60 Missouri counties declared themselves Second Amendment sanctuaries, and sheriffs publicly announced they would arrest federal agents who attempted gun seizures without going through state channels first. The law wasn't symbolic. It had real teeth that could bankrupt careers and drain federal budgets, and it applied retroactively to any officer who had cooperated with federal gun enforcement in the previous 4 years. What made Washington panic wasn't just Missouri's defiance. It was the fact that 33 other states were watching closely, drafting similar bills and waiting to see if Missouri could actually pull this off. But here's what most people missed about why this law was different from every other state gun law that came before it. The Supreme Court precedent everyone forgot about. The legal foundation for Missouri's law came from a 1997 Supreme Court case that almost nobody remembers, Prince v. United States. In that ruling, the court struck down parts of the Brady Handgun Violence Prevention Act, declaring that the federal government cannot force state officers to enforce federal law. Justice Scalia wrote that such commandeering of state resources violated the structure of the Constitution itself, calling it a line that separates a free republic from a centralized government. Missouri's attorneys built SAPA directly on this precedent, arguing they weren't nullifying federal law. They were simply refusing to be commandeered into enforcing it. The distinction seemed bulletproof on paper, and legal scholars on both sides admitted Missouri had found a genuine constitutional loophole. For 2 years, the law sat in this legal gray zone where federal authority and state sovereignty collided without a clear answer. What the Department of Justice did next, though, revealed they weren't going to let a 26-year-old precedent stand in their way. The federal response that broke protocol. The Biden administration's lawsuit against Missouri broke nearly every norm of federal-state legal disputes. Typically, the Department of Justice waits for enforcement conflicts to arise before filing suit. But they moved within 47 days of SAPA's passage, one of the fastest federal challenges to a state law in modern history. Court documents revealed the real trigger. ATF agents in Missouri reported that local police were refusing to share databases, declining to participate in joint task forces, and in 3 documented cases, actually warned gun owners that federal agents were coming. The Justice Department's emergency motion claimed that violent crime investigations were being actively obstructed, citing 14 specific cases where federal prosecutions stalled because Missouri agencies withdrew cooperation. What made this lawsuit unprecedented wasn't just its speed. It was the aggressive legal theory that states have a constitutional duty to assist federal enforcement, a claim that flipped the Prince decision on its head. The DOJ's legal team warned that if Missouri succeeded, it would create a blueprint for states to selectively ignore any federal law they disagreed with, from environmental regulations to civil rights protections. The district court's response came even faster than the lawsuit itself, and what the judge wrote would become the blueprint for destroying state resistance nationwide. The judge's ruling that rewrote state power. When Judge Brian Wimes issued his ruling, he didn't just block SAPA. He created new constitutional doctrine that legal experts are still debating. His 24-page opinion declared that while states cannot be forced to enforce federal law, they also cannot actively obstruct federal enforcement through financial penalties or legal threats against their own officers. The injunction went further, prohibiting Missouri from even educating its officers about their rights to refuse federal cooperation. Within the ruling, Judge Wimes cited collaboration statistics showing that joint federal-state operations in Missouri had dropped 73% in the year after SAPA passed, arguing this proved the law's disruptive intent. Gun rights groups immediately recognized the danger. If this reasoning stood, states would lose their last tool for resisting federal overreach. When Missouri appealed to the Eighth Circuit, they thought 3 conservative judges might see the constitutional crisis differently, but the panel's decision revealed something unexpected: the appellate disaster and Justice Thomas's warning. The Eighth Circuit's unanimous affirmation shocked Missouri's legal team, because one of the judges, Ralph Erickson, had previously ruled in favor of gun rights in 3 separate cases. His opinion, affirming the injunction, used language that seemed copied directly from the Justice Department's briefs, calling SAPA an attempt to unilaterally declare federal statutes void. What the panel refused to address was Missouri's core argument, that financial penalties against state officers were fundamentally different from ordering states to enforce federal law. The ruling created an immediate crisis for 8 other states with pending SAPA-style legislation, forcing governors in Wyoming, Oklahoma, and West Virginia to halt their bills mid-session. When Missouri filed its emergency appeal to the Supreme Court, every major gun rights organization filed supporting briefs, some running over 100 pages, with historical evidence of state resistance dating back to the Fugitive Slave Acts. Justice Thomas's lone dissent from the 8-1 denial didn't explain his reasoning, but his chambers later released a statement noting he would have granted full review, signaling he saw a constitutional question the other 8 justices wanted to avoid. The court's silence left everyone guessing, but what happened when Trump took office made the situation even more confusing. Why the Trump DOJ abandoned Missouri. The Trump administration's reversal caught everyone off guard, because during the campaign, officials had specifically praised Missouri's SAPA law as a model of state resistance. But internal DOJ memos later revealed the reasoning. Trump's attorneys feared that defending SAPA would set a precedent that blue states could use to refuse federal immigration enforcement, creating a constitutional crisis that would cripple executive power across every policy area. Missouri's Attorney General Andrew Bailey publicly called it a betrayal, and within weeks, state legislators introduced a revised SAPA 2.0 that attempted to work around the Trump DOJ's limitations. The legal chaos has left the case in limbo, bouncing between district court hearings about what parts of SAPA can be salvaged, and the Supreme Court remains silent about whether it will ever take up the core constitutional question that started this entire fight. Behind closed doors, Republican senators privately warned the White House that abandoning Missouri could cost them critical support in swing states where gun rights remain the single most important voting issue. The Supreme Court's 8-1 decision didn't end Missouri's fight. It just forced the battle into new territory where the line between state power and federal control is being redrawn in real time. Every ruling from this point forward will determine whether states can truly resist Washington's reach, or if federal authority will crush any attempt at pushback. If you want to stay informed as these cases shape the future of your constitutional rights, subscribe now and turn on notifications so you don't miss a single update on the legal battles that matter most. Share this with every gun owner who needs to understand what's really happening in these courtrooms, because your rights won't defend themselves, and neither will your ignorance protect you when they're gone.